Good morning, everyone. Welcome to Assembly Judiciary. Welcome to those here in Carson City, as well as anyone that may be there in Las Vegas. But of course, those watching online, either through our legislative YouTube channel or through Nellis. And with that, Committee Secretary, please take the roll.
Assembly members Cole, Dahlia, Gonzalez, Gray, Hanson, Hardy, LaRue Hatch, Marzola, Moore, Nadeem, Orentlicker, Roth, Urick, Chair Miller.
Here, and please mark Assembly Member Nadeem absent excused. Please mark Vice Chair Marzola present when she arrives. Assembly Member LaRue Hatch present when she arrives. And Assembly Member Cole present if she arrives. Okay. I think we have, and Assembly Member Roth, she's also next door too. So we just have folks in different committees presenting right now, but Assembly Member Nadeem is absent excused. Thank you for that. So before we get going, just a few reminders asking that everyone turn the volume down on any of their electronic devices. We will have 2 bill hearings today, and then public comment, asking that people keep their presentations to 15 minutes, and anyone making public comment or testifying on a bill, please keep your comments to 2 minutes. We also will remind you to state your name for the record, and the first time to also spell it so we have it correct. With that, those that will be testifying or making public comment today by telephone, the phone number is 888-475-4499, and the meeting ID is 830-485-22084. And with that, we will go ahead and go into our bill hearings. So I'm going to open up the hearing for Assembly Bill 550.
Good morning, Chair and members of the committee. My name is Drew Cross, D-R-E-W-C-R-O-S-S, and I'm the State Forensic Program Director. I'm accompanied today by Dr. Ronna Dillinger, Deputy Administrator of Clinical Services. Thank you for the opportunity to talk with you about AB 550. We'd like to offer a brief overview and then be available to answer any questions. AB 550 suggests changes to NRS 178.461, which allows for up to a 10-year commitment at a secure forensic facility for individuals who have been found incompetent with no substantial probability of becoming competent in the foreseeable future for any Category A and certain Category B felonies. However, there is presently no requirement that an individual actually receive restoration treatment prior to the district attorney filing a motion to direct the division to perform a comprehensive risk assessment as to whether or not they require long-term inpatient forensic care. The first proposed alteration would require a defendant to receive restoration treatment prior to being found incompetent to proceed for these serious charges. Currently, the division has had to perform a risk assessment on multiple individuals in the detention center who were found incompetent to proceed by the court without ever receiving restorative care. This change would give the defendant the opportunity to become competent, to address their charges, and provide a stabilizing treatment environment. Given the possible 10-year commitment to the division, it seems reasonable to at least attempt to bring a defendant to competency. The next alteration requires that the risk assessment be ordered by the court. Presently, the district attorney files the motion, which is then supposed to be sent to the division. However, in practice, this does not occur promptly and has led to some significant delays. Requiring a court order is likely to streamline this process, since courts are familiar with sending orders to the division, as they would simply follow the same procedure as they do when ordering an incompetent defendant for restoration treatment. If the risk assessment determines the person does not need inpatient forensic care, there is a rebuttable presumption that the person does not require placement at a secure forensic facility. Finally, individuals committed under the statute and who are placed on conditional release, and/or eligible for discharge from conditional release if it is granted, the facility and its agents are not liable for any debt, contractual obligations, or medical expenses incurred by the person or any damages the person causes. Passing AB 550 will assure appropriate individuals are committed for long-term care, streamline communication regarding the risk assessment, and lead to consistency across the state. Thank you for your consideration of this bill, and we're happy to answer any questions.
Thank you so much. Let's see. Okay, I don't see any questions right now, so with that, I can go ahead and open it up for testimony. So we will ask you to step back from the table so as others approach for testimony. Is there anyone here in Carson City that would like to testify in support of AB 550? Not seeing anyone? Is there anyone there in Las Vegas that would like to testify in support? Also not seeing anyone. Broadcasting, will you open the line, please?
If you would like to testify in support of Assembly Bill 550, please press star 9 now to take your place in the queue. Chair, there are no callers wishing to testify in support at this time.
Thank you. Then I will open it up for opposition testimony, beginning here in Carson City.
Good morning, Angela Knott from the Washoe County Public Defender's Office, Angela Knott. Our opposition is specifically geared towards Section 1. And in speaking with the sponsors, we have submitted a proposed amendment, and it's basically just tweaking the language from removing "and the defendant received treatment" to "competency," which is on page 2, line 5, and expanding it as to what that actually means, because when you read it, it appears that the defendant maybe did become competent, and in which case the rest of this bill doesn't really apply. So we're working on the language to show that someone tried to be treated to competency, but were not able to be treated to competency. So we are still working with the district attorney's office and the sponsors to finalize the language on that section. Thank you.
Good morning, Chair Miller and members of the Assembly Judiciary. Paloma Guerrero, PALOMAGUERRERO, on behalf of the Clark County Public Defender's Office. I'll speak to our proposed suggestions for Section 1, Subsection 2. And speaking with the sponsors, we let them know about our concerns about this. So right now what the process is that when somebody is found incompetent without the probability of being restored, the DA files a motion with the court asking for a risk assessment, some sort of danger evaluation to see whether that person should be civilly committed. If the doctors find that they're not a danger, the current process is then the case is just closed, that person gets released. What they want to change it to is that it creates this rebuttable presumption, meaning that now the prosecutor is going to have a chance to rebut that rebuttable presumption. And so we find that there's no issues with the current process. We want the process to go back to how it originally is now. And we did speak to the sponsors about this. They did seem amenable to just going back to the original way. And if we are now requiring that the court place an order for this danger assessment, there's deadlines on here about when the prosecuting attorney should file it. We just need a number of judicial days for when that order should actually be filed, so that the orders aren't just out there languishing, especially for people that need this danger assessment. Thank you.
Thank you, Chair Miller, members of the Assembly Judiciary Committee. My name is John Jones here on behalf of the Nevada District Attorneys Association. Pursuant to the rules of the committee, we are in opposition to AB 550, but I can say off the bat that I do understand the intent, and I do think we'll be able to get there. We did have a meeting yesterday with Director Cross and Dr. Dillinger and others to work through our concerns, and I do believe we'll get there. Just briefly, we have some concerns about filing a notice and a motion. I think we'll be able to consolidate those two into one filing. Additionally, as Ms. Knox indicated, she does have a proposed amendment to Section 1. We have some concerns with her language, but again, I think we'll be able to get there. Our concerns lie in the interplay between the current competency process and the potential process in Assemblywoman Roth's AB 467, should that pass. So we want to make sure that we've tightened everything up. Thank you, Chair.
Is there anyone else wishing to testify in opposition? Not seeing anyone here in Carson or in Las Vegas. Broadcasting, will you open the lines?
If you would like to testify in opposition to Assembly Bill 550, please press star 9 now to take your place in the queue. Chair, there are no callers wishing to testify in opposition at this time.
Thank you. Then I will open it up for neutral testimony here in Carson or in Las Vegas. Not seeing anyone. Broadcasting, will you open the lines?
If you would like to testify in neutral for Assembly Bill 550, please press star 9 now to take your place in the queue. Chair, there are no callers wishing to testify neutral at this time.
Thank you so much. Then I will welcome the bill presenters back up for any final remarks.
Drew Cross for the record. We are currently collaborating with our PD NDAs and believe we can reach consensus on AB 550.
Thank you so much. And with that, I will go ahead and close the hearing on Assembly Bill 550. Next, I will open the hearing on Senate Bill 142. Senate Bill 142 revises provisions governing property that is exempt from execution. That sounds pretty fancy, Senator. So with that, your hearing is open, and I just ask that you and your presenters state your name, spell your name for the record, and whenever you are ready, you may proceed.
Thank you, Chair, and good morning to the members of the Assembly Committee on Judiciary. For the record, my name is Fabian Danyate, and I'm proudly representing Senate District 10, which is in the heart of Las Vegas. Today, we are here to speak on Senate Bill 142, a measure that seeks to strengthen Nevada's self-executing bank account protections and enhance wage garnishment safeguards. Today, I'm joined by Mr. Jonathan Norman, who's right here with me, and Taylor down south. They are both from Nevada Legal Aid for any questions that the committee members may have. Today, we will review the language and background of Senate Bill 142, explore related national trends, and discuss the solutions proposed by this bill. Senate Bill 142 is an act relating to civil actions. It requires the Department of Taxation to adjust monetary amounts set forth in provisions governing property exempt from execution every 3 years. It revises the amount of disposable earnings of a judgment that is exempt from execution under certain circumstances. It revises the definition of earnings for the purposes of provisions governing that exemption, and revises the amount of money held in a personal bank account of a judgment that is exempt from execution. So what exactly are we talking about today? Families across the country, already pushed to the financial brink by soaring inflation and rising housing costs, now carry a staggering $1.17 trillion in credit card debt. In Nevada, 20% of residents have debt in collections, with that number rising to 32% in communities of color. For those who are earning the state's minimum wage of $12 an hour, it would take about 85 hours of work each week just to afford a modest one-bedroom rental at the fair market rent. Furthermore, in 2021, 38% of the court filings in Nevada were related to debt collection. Nationwide, in jurisdictions where data is available, over 70% of these lawsuits result in default judgments for the plaintiff, meaning that most individuals are never heard in court. While there is no specific data in Nevada, a recent study in Hamilton County, Tennessee found that fewer than 1% of debt cases with a judgment included claims for existing legal protections, demonstrating that people rarely seek protections that they are entitled to under the law. In Nevada, only $393 in wages for a minimum wage worker and $400 in a bank account are automatically protected from seizure, leaving everything else vulnerable to debt collectors. While it is possible to protect up to $10,000 in your bank account, doing so requires engaging with the courts, something that most people do not often pursue. With the fair market rent for a two-bedroom apartment in Nevada at $1,605 per month, it leaves only just $400 in a bank account that could push a family into homelessness. However, Nevada can follow the lead by other states that have stronger protections in place. For instance, North Carolina, Pennsylvania, South Carolina, and Texas all ban wage garnishment, while Alabama allows workers to protect up to $1,000 a week. On the banking front, Delaware bans bank account garnishment, and New York offers a self-executing protection of $3,840. Nevada has the opportunity to strengthen these protections for its residents, ensuring that individuals and families are not left vulnerable. With that being said, SB 142 aims to protect certain wages from seizure. Right now, the bill, as currently in front of you with the reprint, mentions $850 in wages from seizure, with 90% of wages over $850 also protected, an improvement from the previous protection of $393.60, which is from what we determined from someone currently under minimum wage. It automatically protects $5,000 in the bank account, which is enough to cover the fair market rent and other basic necessities. And the bill right now has a consumer price index adjustment. So because of the fact that many of our constituents are facing the increasing burden of inflation. Really quickly, more now personal notes, less scripted. So this has been probably one of the most negotiated bills that I'm carrying this session. I think within the last 2 weeks, and Jonathan could talk about it as well in his comments, we probably have had, 5 to 7 meetings just within the last week, going back and forth on it. We've tried our best to reach a compromise. We did reach a compromise last evening, which is the amendment that you see presented forward. But we received news this morning that the compromise was off the table. And so we are going to be presenting to you and referring to the conceptual amendment that you have before you today, which Jonathan will go over. But I just wanted to be clear that we tried our best to at least make modest improvements to how Nevada is offering. And I think you'll hear that from the folks that come afterward for testimony. I think all sides have worked fairly well within this process, but unfortunately, from the news that we received this morning, we weren't quite just to get there. I think it's because of one word, but we'll hear more later tonight. So, Madam Chair, if we can let Jonathan just go over the amendment, that would be greatly appreciated.
Chair, members of the committee, Jonathan Norman, NORMAN with the Nevada Coalition of Legal Service Providers. So the amendment's very simple. It removes the indexing to the consumer price index. So if you're looking at the original bill, that would eliminate Section 1, a good portion of Section 3, 4, Section 6, and Section 7. So anywhere, and why it's throughout those sections is we have statutory forms around writs of execution and garnishment, and so each one of those forms had to reflect the indexing to inflation. So that would be out of the bill per the amendment. And then the garnishment protections are moved to $750, and then 85% of the take-home pay for the work week that exceeds $750 if the gross weekly is under $1,200, and then 80% of the take-home pay above $750 if it's over. And this reflects in statute, so I know that's super clunky language, but that's how it's laid out in the statute. So we have 3 different tiers, right? A base amount that's protected, that's the $750 in the amendment, and then we protect a certain percentage of the amount over that for people who make less than $1,200, and a different amount for those who make over $1,200. And then finally, the wild card exemption, it feels like a powerful protection because it's $10,000, but in practice it is very hard to make function. So this amendment would not allow that to be used for wages. So for a consumer trying to do that, they're going to court like every pay period and filing paperwork to try to use that exemption for their wages. And so this enhances the automatic wage protection, still keeping the wild card exemption to be used for other assets. And with that, I think we're ready for questions. We have Taylor Altman, who works in this every day. Not part of the presentation, but if there's questions, she's the expert.
Wonderful. Thank you so much. With that, our first question will come from Assemblymember Cole.
Good morning. Thank you for the presentation. So you had mentioned that I think you said fewer than 1% of people who are in this situation avail themselves of the courts and they end up with the summary judgment or default judgment. So I guess my question is, do we have any data as to why people are not doing that? Is it, they just don't understand the system? Is it that they know that they incurred the debt and so they know that they don't have a valid defense? Or, is it, what's the reason for that? Thank you.
Jonathan Norman, for the record, thank you for the question. I don't think it's, I think the data is how many people are able to use the current protections we have in the law. So, whether you have a defense, once you get a judgment, so this is post-judgment, what can you protect as the debtor? And what we find nationally is when you don't have automatic protections, so, for example, automatically a bank has to protect X amount. So if you make it anything where that debtor has to file paperwork with the court, that's not automatic, it reduces their ability to engage. And to put it into perspective, and Taylor could shed some light on this, we were talking about this last night, for that wild card exemption, you're going to court every 10 days as a consumer, right, to protect the amount of your wages above that. And it's a complicated process versus just saying, we're going to protect this base amount, it's going to be automatic. So for garnishment, that's going to your employer. There's a formula, they're going to protect that amount. And as a consumer, it's automatic. So you just have to go to work, they're going to garnish the amount that they're allowed to. It's going to be a transaction between the creditor, your employer, and you're just going to notice that you have less money. And for the protections with the bank account, the same. Like that goes from a writ of execution, goes from your creditor to the court, then to the bank, and they're going to automatically protect an amount. So the key is making things automatic. And for perspective, I think there's a nonprofit that gauges how much automatic protection matters, and I think we're ranked 46 in the country for automatic protections that don't require consumers to do anything. And this bill would move us into the 30s, so we're still not in the top half, but it's, progress.
Taylor Altman, for the record, TAYLORALTMAN. Thank you, Jonathan, and thank you to Assemblymember Cole for your question. Just to shed a little bit more light, I am a staff attorney at the Legal Aid Center of Southern Nevada here in Las Vegas. And we see a number of people that come in pretty much on a weekly basis who are just finding out that they got sued when their wages are garnished or their bank account is attached. And as Jonathan was saying, it can become very complicated for judgment debtors to be able to take action because there are already these statutory protections on garnishment. So someone could be garnished, be able to keep 82%. They could also be able to keep 75%, but that means that they're going to be garnished 18% or 25%. And a lot of our low-income clients just simply can't afford that. So they will have to try to use an exemption like the wild card to exempt wages that are not already exempt by some other exemption, which means they'll be filing a form called a claim of exemption. And if they're not able to get legal assistance through Legal Aid Center or one of the other legal nonprofits in town, they are, as Jonathan said, every 10 days of the withholding, going to court, filing the claim of exemption. They're subject to very strict deadlines, service requirements. They have to serve the garnishee. They have to serve the judgment creditor's attorney. They have to serve the sheriff or constable. These are really big barriers. So raising the amount of automatic protections will really be beneficial for so many Nevadan families and low-income individuals. I'm happy to take other questions as well.
Sure, proceed.
So the list of exemptions that are in statute now, and plus what you're amending here, those are the automatics, right? Like what we put in statute would be the automatic, and then anything above that is what you have to do on your own.
Yeah, Jonathan Norman, for the record. Yeah, so the one that I think of that's not automatic is the wild card exemption. Yeah, and that's the one that requires you to go to court, and it's the only way to protect any wages that aren't in that formula.
Okay, understood. Thank you so much for the clarification.
Jonathan Norman, for the record.
Thank you for that. I just want to ask, because especially when we're talking about finances, I want to bring it down to 5th and 6th grade language, right? So that we're very clear on what's happening here in the intent. So first of all, this would only apply to those individuals earning a minimum wage.
Taylor, I'm going to send that question to you. Thank you.
Sure. Taylor Altman for the record. Thank you for the question. So the way the existing law is written, you can be garnished up to 18% of your disposable wages. If your gross weekly wage is less than or equal to $770, you can be garnished up to 25% of your disposable earnings if your gross weekly wage is above $770. But then there's also minimum wage protection. So this would apply across the board. So currently, as the statute is written, you can keep 100% of your weekly earnings if you earn, it's 50 times the federal minimum wage, which is $725, which equals $362.50. Meaning that if you earn that amount or less on a weekly basis, you can keep 100%. That all of your income is exempt. The way the law would work under the new bill is any portion of wages greater than $850 is used to calculate the amount that can be garnished. So, for example, we'll say that a judgment debtor is receiving $1,000 in net pay, after taxes for a given week. Only $15 can be garnished. So that's $1,000 minus $850 equals $150, and then that's the portion above $850 that can be garnished. So it's times 10%. They keep 90%. That's only $15 as opposed to $250 under current law, which would be $1,000 weekly wage times 25%. So it does, to answer your question, it doesn't just apply to minimum wage earners, but to all wage earners, and it would be looking at the portion of the wages above $850 to calculate the garnishment, if that makes sense.
Yes, it does. Also, so then you're also saying weekly. So I want to, because there were questions about, so we're looking at weekly wages, not per check or per month. We're looking at per week. So let me ask about individuals who have, oftentimes if people are making minimum or lower wages, they're often hourly employees and hours fluctuate. So as my hours, which means now that my pay would fluctuate, can someone answer that, how it would change if I exceed those limits or come under those limits? Because now we're hearing that there's instances where I could keep 100% of my income. So how would individuals be protected as my weekly wage may actually fluctuate?
Taylor Altman for the record. So the weekly, it's under the existing law, you would look at the gross weekly wage, right? And then you take for garnishment disposable earnings, whereas under the new law, it's just looking at disposable earnings. The SB 142 eliminates any gross weekly salary calculation. But to answer your question specifically, if a salary changes week to week, then the employer would have to do the calculation on a week by week basis to make sure that the amount that's being garnished is fair and under the law, that they're not taking greater than what is allowed. So only the employer would have to look week by week, only the portion of wages greater than $850, and use that to calculate the correct garnishment if SB 142 were to be adopted into law.
And Jonathan Norman, and so I think also on that question implicitly is, do we average like wages throughout the month? The answer is no. It's weeks in isolation. And so if 1 week you only get so many hours, you might have 100% of your pay protected. Whereas the next week, if you get overtime and your, paycheck is a lot higher, you're going to have a higher garnishment amount. And the idea is that the more you make above a certain amount, your percentage is a greater dollar amount, and so it protects lower income folks. Whereas you could, if you're making $5,000 a week, and for some reason you have this, you're going to have a high dollar amount that is subject to garnishment.
Thank you for that. So the onus then is on the employer week to week. Okay. And with that too, the definition, because I know there's oftentimes terms we use interchangeably, as you're saying disposable income. So I hear we say gross income. And so for me, the differentiation is gross and net. For me, disposable is everything you have left after you've paid everything you're obligated to pay. So are we saying that disposable income is net income? Because I can't imagine individuals that are making these wages would claim they had disposable income. So could we just clarify that, please?
Sure, Taylor Altman for the record. So to address that question, in statute, disposable earnings are defined as the part of the earnings that a judgment debtor has remaining after the deduction from those earnings of any amounts required by law to be withheld, meaning the withholdings. And that's not disposable earnings. I think colloquially, probably to most people would mean after I pay my bills, after I pay all my taxes, what do I have left? But the way it's defined in statute is those withholdings, which are usually taken out of someone's paycheck right away, what the amount that they have left after. So I think thinking of it as net pay makes the most sense. And to address another question from earlier, under the current law and under the new law, the 362.50, so those are low-income earners, people making minimum wage, you would take 50 times the minimum wage. They're going to be protected from garnishment under the current law as it stands and under the new law as well. So those protections remain in place for low-income earners. They can exempt 100% of their income if they're earning 362.50 or less per week.
Thank you so much for that. And that is challenging when we use legal definitions that are different from what we use. I mean, it's like wait till you find out in accounting what debits and credits really are, right? Things are always opposite of what we think. And a few more clarifying questions that I only need a brief response to. So this would include all garnishments. So regardless of why our wages are being garnished, whether it's child support, debt collecting, restitution, whatever it may be, this would protect those individuals regardless of what and why that garnishment is. Well, it could be taxes, whatever it is.
Taylor Altman for the record, that is my understanding as well. However, there are such things as super credit, what we colloquially refer to as super creditors, which even if certain income falls under an exemption, so for example, Social Security income, if you owe a debt to the IRS, they're considered a super creditor. They might be able to take some amounts of exempt income. So that's not really what we're talking about here. We're talking about ordinary garnishments. Mostly it's going to come from, debt collectors, creditors, banks, and things of that nature, if that answers your question.
Yes, it does. And one final question from me. Why was a dollar amount chosen as opposed to, say, a percentage?
Taylor Altman for the record. My understanding is that the National Consumer Law Center in negotiations of this bill recommended a dollar amount, for example, $1,000, as protection from garnishment. And as a result of negotiations, it became $850. But I'll allow my colleague Jonathan, if he wants to speak more to the dollar amount versus percentages.
Jonathan Norman for the record. I think Taylor hit it. The National Consumer Law Center recommendation, and then negotiations for the amount.
Okay. Thank you so much. Our next question will be from Assemblymember Hansen.
Thank you, Chair. You said we've said all garnishments when that question was asked, and then we made the exception like super creditors, like say the IRS. But can would child support fall into that range where they can't ever, I kind of see them as a super creditor in the sense that, can they ever be exempt from the garnishment depending on the wage dropping?
Taylor Altman for the record. So yes, so similar to our discussion of IRS as the super creditor, or federal student loans can be a super creditor, similar to someone that is owed child support. There's a higher percentage or perhaps some otherwise exempt wages or amounts can be taken by the person to whom the judgment debtor owes child support.
Thank you. Our next question is from Assemblymember Cole.
Thank you, Chair. I appreciate the indulgence. So my question is, I just want to make sure that I'm clear on the record that in exchange, basically, for increasing the automatic protections on the wage garnishment, that wild card will no longer be applicable, correct?
Jonathan Norman for the record. So the wild card exemption will stay. It just will not be able to use for protecting additional income and wage garnishment. Now, if for some reason the creditor hadn't filed the garnishment paperwork and that paycheck in whole hits their bank account, they could use it for their wages that are in their bank account. So if a creditor is slow, that's then in your bank account, you can use the wild card exemption.
Okay, that makes sense. Thank you. And thank you, Chair.
Thank you so much. With that, not seeing any additional questions, I will open it up for testimony. Beginning here in Carson City, anyone wishing to testify in support of Senate Bill 142.
Good morning, Chair and members of the committee. Leah Cartwright, LEACARTWRIGHT, here today on the behalf of the Leukemia and Lymphoma Society. As mentioned by the Chair and clarified by Legal Aid, this bill would protect garnishment from all sorts of debts, including medical debt, and the Leukemia Lymphoma Society supports any measures that protect those patients, especially as they're going through cancer treatments or their children are going through cancer treatments. So thank you.
Good morning, Chair Miller and members of the committee. My name is Kaylin Cardavani, Kardavani, on behalf of New Day, Nevada. We strongly support SB 142. This bill is an important part of protecting the financial stability of individuals facing debt collection, ensuring that they retain sufficient resources to meet basic living expenses. This bill addresses the economic realities faced by many Nevadans, and as costs go up, we still want people to be able to live and afford the basic necessities of life. SB 142 provides a balanced approach, and we urge your support for this thoughtful and necessary step toward ensuring financial fairness and stability for all Nevadans.
Thank you so much. Not seeing anyone wishing to testify there in Las Vegas. Broadcasting, please open the lines.
If you would like to testify in support of Senate Bill 142, please press star 9 now to take your place in the queue. Chair, there are no callers wishing to testify in support at this time.
Thank you. Then I will open it up for opposition testimony here in Carson City.
Good morning, Chair Miller, members of the Judiciary Committee. Daniel Stewart for the record, DANIELSTWART, here on behalf of Clark County Collection Services. First and foremost, I do want to echo everything the Senator said. The amount of work that's gone into trying to get to negotiations on this bill has been extensive, and they have worked in good faith the entire time. And I also agree with him that I did believe we had a deal as of last night. With respect to the amendment, the changes to the numbers, the percentages in the numbers, we love. We are good with the amendment. But something was flagged late in the evening before I woke up about the difference between going from currently under law gross pay to net pay, and how that being a major difference, and I guess a sticking point that nobody caught before. So at this point, they asked me to pull back into opposition, with the hope that if there was opening to changing it back to gross pay as it is in the current law, we'd be back to neutral. I understand. I want to put this on the record that that amendment was put forward in a good faith negotiations, and if the sponsor needs to pull that amendment based upon our negotiations or how we responded, we understand completely in this process. Thank you.
Good morning, Chair and committee members. I'm Brian Reeder, speaking on behalf of Nevada's credit unions. Nevada's credit unions serve more than 400,000 members in Nevada. Unfortunately, speaking in opposition today, the credit unions also opposed the bill, the original bill in the other house. We do want to thank the bill sponsor and bill proponents. They did share the compromise amendment with us. We had a chance to review it, and unfortunately, the credit unions do remain opposed, but are committed to keep working on this in good faith. Thank you.
Thank you so much. Anyone else here wishing to testify in opposition? Is there anyone in Las Vegas that would like to testify in opposition? Not seeing anyone. Broadcasting, please open the lines.
If you would like to testify in opposition to Senate Bill 142, please press star 9 now to take your place in the queue. Caller with the last 3 digits, 349, please press star 6 to unmute your phone. You may begin.
Yes, my name is Matt Schriever. I'm a member of the Creditor Rights Attorney of Nevada, and I also own 2 small businesses here in Nevada. I'm in opposition to this bill as currently written. I believe this bill is excessive and will be detrimental to both lending and to small businesses that offer small-scale business services to consumers. The bill seeks to increase the current exemption amount of $362.50 a week by 135% to $850 a week. Now, I know inflation has increased lately, but it hasn't increased by 135%. Federal minimum wage has been $7.25 since 2009. According to the Bureau of Labor Statistics, $7.25 in December of 2009 is worth $10.67 in January of 2025. 40 times that amount would be $426.80. Adjusting the exemption amount from $362.50 to $426.80 would be a reasonable exemption amount here. Increasing it by 135% to $850 is not reasonable. Regarding that $850 exemption amount, if you extrapolate that figure out to an annual basis, that would exempt the disposable income of $44,200 or gross income of approximately $52,000, meaning anyone making less than $52,000 would become judgment-proof and uncollectible. If I can't collect from someone that makes less than $52,000, then I'm not going to lend to someone that makes less than $52,000. There goes car loans, there goes loans to buy home furnishings, there goes loans to do landscaping and to build pools. And with that, I echo the remainder of the opposition, and that's all I have.
Sir, could you also spell your name for the record, please? Are you still there?
One moment, Chair.
My last name is Schriever, S-C-H-R-I-E, V as in Victor, E-R.
Thank you so much. Next caller, please.
Good morning, Chair and respected members of the committee. My name is Donald Maurice. That's D-O-N-A-L-D, M-A-U-R-I-C-E. I serve as outside counsel to the Receivables Management Association International, the trade association composed of more than 600 credit providers and those within the credit industry, as as well as those who support the credit industry. We speak in opposition to the bill because on its face, increasing judgment exemptions may seem like it's consumer friendly, but we have to look beyond the surface. The unintended consequences of expanding exemptions here can in fact hurt consumers. Consumers can lose meaningful avenues for recovery. They adjust by tightening credit standards. Creditors will increase interest rates, retreating from certain markets altogether. This disproportionately harms low and moderate income consumers who already face limited access to affordable credit. This is because lenders must price risk, and if judgments are no longer an effective recourse, risk-based pricing goes up, penalizing responsible borrowers. Second, finally, excessive exemptions can encourage strategic default. If a debtor can shield most or all of their assets, regardless of the size of the debt, accountability erodes. That shifts the burden of unpaid debts to other consumers and small businesses who must absorb those losses through higher prices, reduced services. We all wish to protect vulnerable consumers, but we must do so in a balanced, sustainable way. Overly broad exemptions disrupt the credit markets, undermine fairness, and hurt both borrowers and businesses. Thank you for your time. I'm available for any questions.
Thank you so much. Next caller, please.
Chair, there are no other callers wishing to testify in opposition.
Thank you. Then I will open it up for testimony in neutral, beginning here in Carson City. Not seeing anyone here or in Las Vegas. Broadcasting, will you open the lines?
Chair, the public lines are open and working. There are no other callers to testify neutral at this time.
Thank you. Then I will welcome the senator back up and the senator has no final remarks. So with that, I will go ahead and close the hearing on Senate Bill 142. Next on our agenda today is public comment. So anyone here in Carson City wishing to make public comment? Not seeing any. Not seeing anyone in Las Vegas. Broadcasting, will you open the lines?
Chair, the public lines are open and working, and there are no callers to provide public comment at this time.
Thank you so much. So I will go ahead and adjourn this meeting. So as of this moment at 9:17 a.m., we do not have committee tomorrow. However, you know, deadline week, things can change. So if things change, obviously we will post an agenda and I will alert members and let you know. So as of now, so we'll see. With that, we are adjourned. Oh, on Friday, we will post that as well. We'll see you on Friday.